Judge Easter, thank you for the order that you entered this case back last summer, directing the court to enter an order overruling the motion for a new trial. I don't know if you saw some of the correspondence from the clerk's office, but they basically said, pound sand, John, we're not going to do what you're asking to do. And so I appreciate your order saying, trial judge, please put one down. And
I wish I could say that that was one of my finer moments, but honestly, I don't recall it.
Okay.
So but thank you for pointing it out. I'll look it up now.
I have a friend of mine years ago who got down here, and the same thing had happened. And this court sort of went, we're not sure we have jurisdiction. And I asked him a couple of weeks ago what happened, and he said, well, the CCA sent it back to the trial judge to set it for a new trial. And so I was like, oh, well, maybe I needed to wait to get down here. But we have an order overruling the motion for new trial. Ironically, this case is nowhere near as complicated in some ways as Mr. McNally's previous case, but it's about the same issue, the right to present a defense.
Is it?
I think so.
I don't know. I think we need to talk about a few things within your brief,
Okay.
Mr. Nesbitt. The first issue, well, there are a couple of issues of waiver that I would like for you to address. In your first issue, you argue the trial court erred in prohibiting you from presenting a defense by allowing the ADA to play a heavily redacted videotape, and you rely on the rule of completeness. Is that fair?
That's one of them, yes, Your Honor.
Okay. And in response, the state says that's just simply not true. The trial court gave you the opportunity to play the entirety of the video.
She said I could. I did not have a copy of it and in a position to play it.
What does that mean?
Well, that means, well, you've gone through trials, Judge. We start a trial, and this is a misdemeanor, and so there's not a whole lot of work involved. You know, pretrial motions, few pretrial motions, no jury instructions before we get to court. My sole hope in this whole case is I can convince a juror to wonder what the state's leaving out. I live in a world of sovereign citizens. I live in a world of people that
Let's talk about this issue. I understand all of those things. This issue, where the state had given you the copy of their redacted version of the video.
Correct.
In advance of trial.
Yes.
And you knew that the state was going to present a redacted video.
And I wanted them to play the redacted video.
Well, of course, because they had excluded inadmissible evidence from the video. Right?
I wanted them to play their video because I was then going to argue to the jury, what are they leaving out?
Okay, so I'm very confused now. But you're arguing, you were going to argue to the jury what they were leaving out, but your issue is that the trial court prohibited you from presenting the entirety of the video.
My real issue is stated in a footnote in the state's brief.
That's not good if it's stated in a footnote.
Well, the state also redacted other content, including HG and field sobriety tests, because the state did not want to elicit inadmissible officer testimony about the test. My whole concept today here, Judge, is we're allowing officers on the scene to conduct a test that is not admissible in court.
Well, that's not the issue. That's not the issue. The issue is that the trial court prohibited you from presenting a defense concerning the playing of the entirety of a video.
That's one issue, Judge. The second issue is the jury instruction she gave concerning the redacted video that says some version of don't worry your head about what I've redacted it, and you just need to pay attention to that. It is the jury instruction that presents the biggest problem of me not being able to have a defense. And that is, I can't then say, she says it, I can't then very well say ethically, I don't think, and there's just a big discussion in the trial with the jury out of what the box she's put me in. My whole trial strategy has been, my defense is, what is the state not showing you?
Counsel, is that argument included within the scope of your issue that you stated as your first issue? And the trial court erred by prohibiting appellant to present a defense when the trial court allowed the assistant district attorney general to play a heavily redacted videotape of the appellant during the traffic stop to the jury statute. And does that even reference the jury instruction issue?
I think I eventually do. It's been a minute since I've looked at my brief, but that was on page 9. I talk about the trial court erred in giving the jury instruction. The biggest issue I have here is that this court and our Supreme Court continues to allow police officers on the scene to conduct tests that aren't admissible.
That is not in your brief. I want you to address the issues in your brief.
Okay. So the first one was, let them play a redacted version. Yes, they offered me the ability to do it. She did not do that before I was standing in court that morning. The trial judge did not. I did not have.
Did you seek a continuance, counsel? Did you, and you're essentially suggesting that you were surprised, or was there any motion for a continuance here?
It wasn't a motion for continuance.
So-
Given the fluid nature of what was happening, I guess, Judge, I just didn't really think about asking for a continuance. We have a jury in the box. The judge says, well, yes, you can play the whole thing if you want. I don't know if she ever really said that.
I think the judge did allow you to play the entirety
I think,
of the video.
it's been a minute since I've retried the
That's why I was
case,
very
Judge.
confused about your issue.
So I could have asked for a
Counsel,
continuance.
let me
Yes,
read you
Judge.
something from the transcript. And this is talking about the video. And that will be your choice in your presentation to prove whether you play that portion of the video or the entire video. If you choose for the jury, as you articulated well, you have a defense to put on in the manner that you see fit. And that seems like the trial judge is giving you permission to play the whole video, play part of the video, and it's really your choice. And if you're not ready that day for that ruling, wouldn't the proper recourse have been to move for a continuance in that circumstance?
I guess, Judge, yes, with perfect 20/20 hindsight, or even partial 20/20 hindsight, yes, it would have been at least an opportunity, and that would give me another issue on appeal to say she denied my motion for a continuance.
But doesn't this take away the issue that you have stated on appeal, which is you're saying that the trial judge didn't allow you, and I'm struggling to see how we can read that as anything other than the trial judge did allow you to play the whole video. You may not have been prepared to play the whole video.
Certainly wasn't prepared to. And she did, I guess you're right. Judge, she did allow me to play it, and I chose not to. That's
So,
probably the short answer.
as I understand your position, is that you didn't want the whole thing played to the jury so you could make this argument of what are they hiding from you?
In essence, Judge, you're exactly right.
So, I mean, if you carry that to what if the fact that the officer told your client, this is your third DUI, would you want that played to the jury
Oh, there's-
too? Are they hiding something there?
There's a whole lot there I don't want in there. My
That's
client
what I
admitting how
thought.
much he'd had to drink, prior
What
convictions.
you would be doing you would be lying. That would be disingenuous. That would not be permissible because you would be untruthful.
I'm sorry,
You
Judge.
know something is on that video that is inadmissible evidence, and you are trying to capitalize on that inadmissible evidence by misleading the jury. That is improper conduct.
Judge McMillan, there was a lot of, often I was in a position during this trial of wondering where my ethics were, where the line was. Because when the judge gives the jury instruction that she gives that says, don't worry about what I've excluded, I can't then, I'm sitting in court. First time I hear this is at almost the end of trial, and I'm thinking, what are my ethics? I can't very well argue to the jury what I had been planning to argue, which is what do they leave out? Because the judge is going to tell the jury in a few minutes, don't worry about what was left out. And so, yes, ma'am, I did not want, you said, well, Judge, I didn't want to play the whole thing. And so
As Judge McMillan would say, play games with the jury?
I was not playing games with the jury. My sole focus is on what are they not playing, what are they not showing you?
Which you knew was information that was not admissible.
No, the big point was the HGN.
Not admissible.
And why is it not admissible? Why does this court continue to allow police officers to form their probable cause basis based on inadmissible evidence? That's my whole point today.
That wasn't the only thing, and that's not at issue here. It would be a totally different question if you had raised that as an issue. You did not.
I do on page 9, Your Honor.
Your issue, that the fact that the HGN is improper for police to make a probable cause determination?
I do in my brief discuss that, yes. At
That's
least
one of your issues presented, sir? If it is, you should point it out, because I honestly, the state has moved to, I guess, waive the bulk of your brief in this case. And I'm concerned that I was unable to follow much of your argument. So you're telling me now, I don't want to make you uncomfortable, but that is not an issue presented.
Fine, Your Honor. Let's talk about sentencing. My client has a health problem, talked about it at the sentencing hearing. The judge basically punished him by giving him 11 months and 29 days to serve. The state, and I'm not quite sure what this is about, says that that is the sentence for a DUI third offense. Well, I think the statute says the minimum is 120 days, not 11 months and 29 days. And so I would submit to this court that the sentence is excessive and should be reduced to at least the minimum. And Judge, I will concede that you're probably right. I didn't frame the issue correctly in the motion for new trial or into this brief to talk about it. And I'm not quite sure that it's addressable, but those are the problems. But the jury instruction is...
I encourage you, if this is an issue that you're passionate about, of course, present it. But we prepare for argument in this case based on what the parties present. If you don't present it, you can't argue it. We won't consider it.
I understand, Judge. I understand. Sentencing is a big issue. I would urge this court to reduce the sentence to a minimum of 120 days. I understand your point, Judge, about the other ones. The issue about the juror that should have been excluded, although I asked the clerk...
She was excluded, correct?
I excluded her, yes. And so I didn't have, I don't have the argument that I had an incompetent juror.
Can I ask if you withdraw that issue for purposes of our response to
Yes, ma'am.
So you do withdraw issue 2?
And I'll sit down before I'm forced to withdraw anything else.
Thank you, sir. State. Mr. Groves?
Good morning, Your Honor. May it
Morning.
please the court. Alan Groves on behalf of the state. This court should affirm the defendant's DUI convictions because he failed to show a violation of his constitutional right to present a defense. There's overwhelming evidence to support his convictions. The court should also affirm his sentence of 11 months and 29 days in confinement, and all the other issues have been waived or withdrawn. So I will agree with my friend on the other side about one thing. This case is much more simple than the previous case. The core of the appeal concerns this constitutional right to present a defense. And Judge Usman, as you pointed out, it's pretty clear from the transcript, which we reproduced at page 13 of our brief, that the trial court simply did not exclude this evidence. It did not prevent defense counsel from playing either an unredacted copy of the video or a redacted copy of the video that just kept the statements about his prior convictions out. He just wasn't prepared to present that evidence. And the trial court also did not limit cross-examination in any way. Or rather, the trial court told defense counsel, if you want to ask the trooper if he performed the HGN test, you can do that as well on cross if you're not prepared with the video. He chose not to do that either. And it does seem, Judge Easter, like the strategy was to play games with the jury to some extent, which prompted several objections by the prosecutor throughout this trial. There were many objections by the state because it's simply improper to ask the jury to speculate about things that are not in evidence. And that's why the jury instruction was proper. Judge Usman, I agree that the jury instruction issues are technically, maybe could be considered discrete issues that don't even fall within the scope of this constitutional right to present a defense. I chose to, out of an abundance of caution, just go ahead and address those on the merits.
Is that jury instruction issue properly before this court?
I believe the defendant did challenge it contemporaneously in the trial court, and it was in the motion for new trial. The court could deem it waived for it not being designated in the statement of the issues, except insofar as it might be able to be assimilated under this constitutional right to present a defense issue, which is kind of how I addressed it, just so that the court could have the benefit of full briefing. Sometimes the court, if we make a waiver argument without it being in the statement of the issues, but it's clear that in the argument that that's what they're raising, then the court will sometimes address it on the merits. So that's what I chose to do here. But the court could take a more aggressive stance on waiver and deem those arguments waived as well, I believe.
Well, the only issue that I see that it could possibly be shoehorned into is whether the trial court erred by admitting into evidence a heavily redacted videotape of the defendant made during the traffic stop.
Exactly, I agree. I think that's, and even that issue statement is phrased, I believe, as whether the trial court erred by admitting into evidence the state's heavily redacted videotape. But then when you read the argument, it's clear that what he's really arguing is that the court was excluding his evidence, which again was not the case. So again, I'm just being the most charitable I can with the issue statements that were presented and the arguments that were presented later in the brief and trying to make the most sense of it as I could. If the court doesn't have any further questions about that issue, I won't belabor the point. Just one point about sentencing, since defendant brought that up. So I did say that the court was required to impose a sentence of 11 months and 29 days, and the issue is really the manner of service. That's because in TCA 5510-402E, that's the provision that says the court is required to impose the full 1129. At least 120 has to be in confinement, but if it only imposes 120 days in confinement, the balance has to be on probation. So that's where I'm getting that, and I think that's how this court has construed that statute. The length is set, but then it's up to the trial court to determine the manner of service. And clearly the court considered all the relevant sentencing principles. It found that he had multiple DUI convictions, that he lacked candor with the court, and at trial with the inconsistent statements he made. So it was well within the trial court's discretion to impose a sentence of full confinement. If there's no further questions, Your Honor, we just ask that the court would affirm.
Okay. Thank you, Mr. Groves. Mr. Nesbitt, did you have rebuttal time, sir?
I didn't reserve any.
All right, thank you. The matter will be taken under advisement. We appreciate the parties' arguments and briefs. The court's going to take a 10-minute recess.
All rise.